So we talked a little bit in the video above about what is a provisional patent application. If you missed that, you can go up, just scroll up a little bit and you can find that information and watch about that. Now I'm going to talk a little bit about non-provisional patent applications. This is the one that you always hear about, hey, I filed a patent application. It's going through the examination process for patentability. That would be a full patent application or what's called a non-provisional patent application. So non-provisional patent application, few things to know about. So one is it is a full patent application. It has all of the formalities, it has the drawings, it has a full description of your invention, has what's called a claim section to define what your invention is, and it has all of that. Once you when you want to do a non-provisional, we will prepare it, assuming you want to move forward, and we will then get filed with the Patent and Trademark Office. Then it gets put in a queue for examination. During that queue, it usually takes somewhere between 12 to 18 months to get up to the top of the queue to get to the top of the queue for examining as to whether or not it's patentable. Now, during that time, as soon as you file the patent application, as soon as you put it on file, the date that you file it, you get patent pending. You define your date of invention. It says, as of this date, I claim the rights to this invention. Should it be patentable, then anybody that comes along after this date, they would bump into me and they would be infringing on my rights because I was the first to invent it. And so that's the one thing. Patent pending basically means you filed your patent application, you believe it to be patentable. Now, when you do a non-provisional, it usually takes us about 4 weeks to prepare and file it. And so once it's filed, you get put in that queue. When they look at that queue for what to be examined, really has two standards, sometimes three. The main standards are what's called novelty, obviousness, and abstraction. So novelty is, has anybody else previously invented this? If somebody else has previously invented it, you're not able to get a patent on something that's already been invented. Obviousness kind of has a couple different meanings. Obviousness can mean, hey, yes, not one person has invented what you have done, but if you were to take two or more things that are already out in the marketplace in the industry, it would have been obvious you could have combined these together. You're not really adding anything new. You're just taking a couple things already out there, putting them together. So that's one thing of obviousness. If all you're doing is taking two things that are already out there, putting them together in an obvious way, then you don't have anything patentable. If you put them together in a unique way, or it's two things that don't mean to go together, that's patentable. But if it's just an obvious combination, not patentable. The other thing can be, hey, what you're really doing is taking an obvious variation of what's already out there. As an example, I'm taking a vehicle, and nobody's ever thought to paint a vehicle blue. And so I went and took what was normally a black car, and I painted it blue. Well, yeah, they're saying, hey, that's not really, you're not adding anything unique or different or new. You're just taking something that's already out there, making a minor tweak that's very obvious. And again, you can't patent it. So novelty, you can't patent something that somebody else has already invented. Obviousness, you can't combine two things in an obvious way, or you can't just make an obvious tweak to something that's already out there. The last thing, and this one's primarily more to do with if you're in the software arena, is what's called abstraction. And basically, if something is abstract, it means that you're trying to take something that people have already been doing in their head, they've already been doing on pen and paper, and you're just trying to stick it on computer or a device and saying, hey, it's new, it's different, it's unique because I took something that everybody's been doing my pen and paper and I put it on a computer. You can't do that. So you can't take 2 + 2 = 4, put it on a computer, say now I've created something new and patented. But what you can do with a lot of times with software is how you're implementing it. Let's say, as an example, you've got a new way to do something different with software. And yes, people have been kind of doing it by pen and paper, but it's so inefficient, it's so difficult, takes so much time, it doesn't work as well, it doesn't have as much uniqueness to it. If you're doing something different in that nature of software, absolutely overcome abstraction. So and it can also be how you're putting all this data together, how you're analyzing it, what steps you're taking in order to make something new and different with the software, how you're providing notifications, how you're doing analytics, all of those things, how you're interacting with multiple devices or getting information, taking inputs, getting an output. All of those are going to be potentially patentable with abstraction, but you just have to make sure what you're not doing is just taking what people have done, pen and paper or in their head, putting it on a computer, on a processor, calling it new and trying to patent it. That's not able. So those are a few things to think about with a non-provisional is, you want to file it, your patent pending as of the day you get it, or file it, you get a date of invention. It lasts for 20 years from the date that you file it as an exclusivity you get with the patent application. You got the 3 standards for as far as patentability that you may want to watch out for as it goes through the examination process. And there's a whole bunch more, but that gives you kind of a quick introduction to a non-provisional patent application. Look forward to talking with you a bit more about it during our strategy session.